Hello guys, this video will cover the second chapter in our series on company and partnership law. This chapter is titled Company Law. In the first chapter, we talked about sole proprietorship and partnerships, giving general information regarding the formation, registration, and termination of such entities. In this chapter, we are going to do basically the same thing. However, we will be taking a look at companies as a whole. In this video, we will talk about companies with respect to their nature, how they are formed, and the types of companies. Let's dive right in. We will begin with the nature of a company. When we say the nature of a company, we are talking about the qualities that all companies do and should possess. But what exactly is a company? A company does not lend itself to a single simple definition. This is born out of the fact that companies can exist in varied forms and shapes. A company is an entity that is created by law and given a legal status and personality distinct from its owners and officers. A company is usually formed by persons who have decided to associate to do business for the purpose of making profit or for charity. Having said this, let's talk about the qualities of a company. The qualities of a company include 1. A company is an artificial legal person. 2. It is brought into being through registration in accordance with the law. 3. It has members or owners and officers. 4. It is usually formed to carry on a specified business. 5. It requires capital to carry on its business, which can be provided by the owners or through borrowing by the company itself. 6. Capital raised is to carry on the business of the company and not for personal use by the owners and officers. Let's talk about people who may form a company. Anyone or more persons may form an incorporated company by complying with the Companies Act. For private companies, a maximum of 50 people, but there is no registration for public companies. 2. Body corporations may also form a company. 3. A foreigner may also form a company if the required requirements are met. However, there are certain businesses that foreigners are prohibited from joining. A person who is a minor or of an unsound mind may not form a company. Moving on, let's talk about how companies may be formed. But before we do, kindly drop a like and subscribe if you are finding this video helpful so far. To carry on, let's talk about the formation of a company. Section 14 of Act 179 specifies the requirements of setting up a company and the steps to form a company. Promoters and the Registrar General are two people who play crucial role in the formation of company. Let's talk about the role that promoters play. Section 12, Article 1 of Act 179 specifies that any person who is or has been engaged or interested in the formation of a partnership is a promoter. This, however, does not include a person who is acting in a professional capacity for the persons who are interested in forming a company. So a promoter is the term or the name used to qualify the people who are interested or engaged in the formation of a company. But if someone acts on the behalf of people who want to form a partnership in a professional capacity, that person does not qualify to be a promoter. In order to form a company, the promoters must deliver to the Registrar of Companies for registration a copy of the proposed regulations of the company. The registrar will register the company and issue it with a certificate of incorporation and gazette the registration. This happens after the promoters have given a copy of the regulations of the company to the registrar. However, if the registrar is of the opinion that the regulations do not comply with the Companies Act, or the company is being formed for an illegal purpose, or any of the signatories is an infant or of unsound mind, or any of the directors is incompetent to act as such, the registrar will not issue the certificate of incorporation. But what exactly is the regulation of a company? And why is it necessary for registering a company? Well, the regulations of a company is the fundamental document that governs the activities of the company. In a sense, it can be said to be the constitution of the company. The regulations of the company serves the following functions. It sets out the purpose of the company. It defines the limitations of the powers of the company. It sets out the organs and defines the duties, rights, and powers of the organs and the members of the company. It defines the interrelationship between organs, members, officers, and the company. It spells out how the company's internal affairs may be changed from time to time. Now let's talk a bit about the Certificate of Incorporation. The Certificate of Incorporation is issued by the Registrar General to the company with the official seal to authenticate it. If the company is a limited liability company, the registrar must state on the certificate that the liability of the company is limited. The certificate must also indicate the date of incorporation and the name of the company. From the date of incorporation, the company becomes a legal being separate from the owners and acquires a legal capacity to exercise the functions of a body corporate. The effect of a certificate of incorporation is that it is conclusive evidence the company is duly registered and incorporated in accordance with the law. Up next, let's talk about the effects of incorporation on the company. Once incorporated, the company becomes a separate legal entity. This means that the company becomes different from its owners. Incorporation also gives the company perpetual succession, meaning that the company will still remain even after one of its owners passes away. 3. The company will now have the capacity to sue and be sued, and also the capacity to acquire its own property. Incorporation separates corporate assets from personal assets. It also gives the capacity to borrow and create charge over assets and to enter into legal relations. Finally, incorporation makes the company a taxable unit. Having spoken about this, let's talk about the types of company. Now, the Companies Act of 1961, Act 179, has two categories of companies. The first, limited liability company. A company may either be limited by shares or limited by guarantee. The second category of companies specified by the Act is unlimited company. Let's talk about these two categories. First, the limited liability company. A limited liability company is also called a company limited by shares. What this means is that such companies have the ability to form a legal protection for their shareholders and owners. This protection prevents the owners from being held personally responsible for the company's debts or financial losses. The advantages of limited liability companies are that they provide protection to their shareholders against creditors. They also allow shareholders to diversify their holdings and become shareholders in several companies, knowing their liability is limited to the investment. 3. It reduces the risk involved in separation of ownership and control. The disadvantages of a limited liability company is that it is very unfavorable to creditors. It encourages irresponsible investments. Shareholders abandon insolvent company and form a new company simply because their liabilities are limited. Also, it renders directors and shareholders liable to creditors through guarantees. Now let's talk about companies limited by guarantee. For companies limited by guarantee, they do not have shares or shareholders, but they are owned by guarantors who agree to pay a set amount of money towards company debts. For unlimited companies, they do not have any limitation on the liability of their members. Though it enjoys all the features and advantages of incorporation, the members are liable to the last person for the company's debts. The Companies Act also makes a distinction between private companies and public companies. For a private company, it has the following restrictions and prohibitions. 1. It prevents the right to transfer shares. 2. It limits the total number of members and debenture holders to 50. Now, if someone was working under the employment of said company and later on became a shareholder, that person will not be included in the number of partners. 3. Private companies do not invite the public to acquire shares or hold debentures of the company. And 4. Private companies are prevented from making any invitation to the public to deposit money with it, either for fixed periods or payable at all, whether bearing interest or not. So for public companies, a public company will be any company other than a private company. A key feature is its listing on the stock exchange, right? So public companies are usually listed on the stock exchange. With all this, we can conclude that there are 6 types of companies under the Companies Act. There is a private company limited by shares, private company limited by guarantee, right? We also have the unlimited private company, and the same goes for the public companies. So we also have public companies limited by shares, public companies limited by guarantee, and unlimited public companies. Thank you very much for watching this video. Please do not forget to like and subscribe. See you in the next chapter.